Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, Father, you done for me, yeah. Words are not enough to say thank you. Say, Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uya matinyana. Uya matinyana. Uya matinyana. Oh, uya matinyana. Yeah, so uya. Uya matinyana. Uya matinyana. Yeah. Uya matinyana. Uya matinyana. Say, I call you Jireh, say. I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are my everything. Yeah. Are you ready, everybody? All right, listen. William Miguel, come here. 1, 2, 3. Yeah.
It's always a pleasure to come your way and also lead the discussion on what matters when it comes to the law, the community, and the law. Do you know you can lose your money in the bank account if you are in the UK illegally? We're going to look at this and also safeguard our money. We have questions you have brought in, and our legal person, Lawyer Charles Asma, will help answer all of them. Welcome to the community and the law, brought to you by BWF Solicitors.
Hello. Yeah, you're good. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn. At BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the law. So pick up the phone and dial 0208 493 7345, or you can send a text 07950 422 780. It's the community and the law. My name is Oreku Frimpong, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello, lovely people. Thank you for being here, and welcome to another edition of the community and the law. My name is Oreku Frimpong. It's my duty and a pleasure coming your way with this wonderful program that brings you the empowerment and also helps you to know what there is that's going on when it comes to the law. We're doing this by courtesy of BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors deal in immigration matters, they handle family matters, they handle property advice, not necessarily going to that, but if you want to have advice when it comes to buying property or the legal bits about it, talk to BWF Solicitors. All immigration issues, talk to BWF Solicitors. They are on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. You can call them and book an appointment on 0208 493 7340. The number again 0208 493 7340. Or if you're in Ghana, they have an office there. 055 589 5959. And emergency situations, and every time you want to contact BWF solicitors, you can send them a text, WhatsApp message, or a voice note on 077 127 61884. 077 127 61884. Ladies and gentlemen, it's another edition of the Community and the Law. We have started a new month, and in September 2025, I'm asking you this very pertinent question. Did you know you can lose your money in your bank account if you are in the UK illegally? You didn't know, did you? We'll be looking at the legal side of that and what it is that you need to know and do about that situation. Lawyer Charles Asma from BWF Solicitors is our resource person and guest this afternoon. But before we go on, let's look at the month of August. At BWF Solicitors, we serve people and give them satisfaction. One of such clients is Amma. And Amma is saying that she's incredibly grateful to Lawyer Charles Asma, BWF Solicitors, for the outstanding work in handling her immigration status. From the very beginning, they showed genuine care, professionalism, and deep expertise in immigration law. The entire team was quite responsive, clear in their communication, and also kept Amma informed at every step of the process. What truly stood out was their attention to detail and how they tailored their advice to her specific situation. They made a very stressful process feel manageable and gave me confidence throughout Amma's years. Thanks to their dedication and hard work. Amma continues to say, my immigration issue was successfully resolved, and now I have peace of mind for the future. I highly recommend BWF Solicitors to anyone needing help with immigration matters. Definitely, you will be in excellent hands. That's feedback from Amma, who has put that on the Google review page and also send it to BWF Solicitors social media platforms. And we want to bring that to you so you also know that when it comes to BWF Solicitors, you have something real good to go with. In the Ghanaian language, they will say, Yawadoye. We have something real good when it comes to BWF Solicitors. So, Amma, thank you very much. Those of you who would want to get in touch with BWF Solicitors, we always tell you to call 0208 493 7340, or the office in Ghana could be reached on 055 589 5959. And in emergency, +44 77 127 61884. You can visit BWF Solicitors on their website, bwfsolicitors.com, or all the social media handles at BWF Solicitors. Thank you very much, Amma, for that. In the month of August, BWF Solicitors, as part of inspiring, motivating members of staff, there is the scheme where one of the members of staff is nominated and voted for as the employee of the month, or the person who excelled in the month. And the work of Cynthia Brown has been recognized by all staff of BWF Solicitors. Employee of the month, as I said, is our practice manager, Cynthia Brown, for consistent performance and dedication throughout the month, consistently delivering outstanding results. And of course, excellence is not just a goal, it is a habit forged by dedication. So for this, Cynthia, we appreciate you for your work ethic. She is one of the very pioneers of BWF Solicitors. She's been here for so long and she knows her work inside out. Now, apart from that, every day is a new day for her and she puts in the extra effort. So, Cynthia, thank you very much for what you do. Congratulations. You are our employee of the month of August 2025. Congratulations. The French will say applaudissez. Well, with that, let's look at what our nugget will be for this week. Earlier in the week, it was put out on our social media platform, and we said It's a criminal offense to provide immigration advice or services in the UK if you are not regulated or otherwise qualified. Unqualified individuals offering such advice can face imprisonment and fines um, as specified below. So I'm going to look at those two. A, on summary conviction to imprisonment for a term not exceeding 6 months or to a fine not exceeding the statutory minimum or both. Then B, on conviction on indictment to imprisonment for a term not exceeding 2 years or to a fine or to both. Now, this one is from sections 84.1 and 91.1A and B of the Immigration and Asylum Act of 1999. So, with that, we welcome our resource person, a brother and friend, and lawyer from BWF Solicitors, lawyer Charles Asma, and definitely a good welcome. We'll be hitting him with the nugget for the day. Uncle Charles, good afternoon.
Good afternoon, Brakoku.
How are you doing, sir?
Very well. How are you?
I'm very well. We've gone past the 8th month. We're in the 9th month of 2025. So, well, we're happy we've been brought this far. And with your support and the empowerment you give us throughout the months, we're happy to come again. And I said that it will be a very nice and interesting welcome to hit you with a nugget. Criminal offense if somebody provides immigration advice without being properly recognized to do that. Take us in on that.
Yes. Thank you very much, viewers and listeners. So we are looking at the Immigration Asylum Act of 1999, and specifically Section 84 and also Section 91. The 84 talks about who cannot do something, and 91 talks about when that person who cannot do something does what they cannot do, what will happen to them. So 91 is the punishment and 84 is the offense. So in the UK, it has always been, but we are bringing this to the fore so that it becomes an awareness and also a refresher for people who are found wanting. We know that there are a lot of people who appear to be friends, family, and colleagues helping out, supporting immigration work, giving advice and doing applications and submitting applications and so on and so forth. And some people call them pocket lawyers. Some people call themselves lawyers and a whole lot. All those people think is that once I can read and write and fill the form, then why can't I do what the qualified people are doing? So the nugget is clear that it is a criminal offense, and the word is criminal. So it's not even an offense which will be taken on a lighter note. It's a criminal offense, and that is quite heavy. So that if you are not authorized, what do we mean by authorized? You are not qualified. You are not a solicitor. You are not a barrister. You are not a legal executive. And you are not regulated or recognized by the Immigration Services Commissioner, what we call the OISC. OISC is the Office for Immigration Services Commissioner. So these are the four categories of people who are qualified to offer immigration advice to people within or in order to the public. So if somebody can read and write and can complete an immigration application form, they are not qualified. If somebody tells you that, oh, I can help you get application done under EUSS, and they help you throughout, by helping the person, the question is, what role did you play? Did you give advice? And how do I show or prove that I didn't give advice? So if you make the representation to the individual to the effect that they are able to do something, and on that basis they went ahead to do something, then that is advice. Mm-hmm. And on that basis on that advice, they carried out an action. either they did it themselves or you help them to do it, then it is an offense because you are not qualified. They, once they make a complaint to the regulators, you'll be in trouble. And what will happen is that you can be in prison for 2 years if it's taken to be an indictable offense, or you can have a fine. Minimum standard is 5,000, but it can even be unlimited within, depending on the circumstances, and it says that up to the maximum penalty point. And you can even have both imprisonment or a fine. So let's be mindful, and this is a warning and advice as well, that much as you are helping, bear in mind that if you are not qualified to offer that help, you'll be in trouble once the person whom you helped feels that they didn't get the best of help from you.
So, Lawyer, let me ask this question quite interestingly. Um, we all have the benefit of this very particular program. You advise us, you empower us to be able to sometimes even put in applications ourselves and all that. So if I did A and it was successful, and the friend says that I want to do the same A, and I tell the person, do it X, Y, Z, follow steps 1, 2, 3, 4. Am I still breaking the law?
What did you do? You advised.
Advised, yes.
You advised. Unless you said that this is not an advice, this is my opinion, this is what I would have done.
Mm-hmm.
You don't have to follow what I've said, but this is how I did it, or this is what I would have done. In this case, it's a suggestion.
Okay.
But if you say that this is what you can do, follow A, B, C, and it will work, or it's likely to work, then you are giving advice. And especially when you continue to take up the case or help the matter and go on with the application and so on and so forth, then you are even going beyond advice. So, yes, remember that it only becomes an issue once the person picks up an issue with you and complains.
Okay.
When there's no complaint, there's nothing. But when there's a complaint, the fact that you are helping them will not be an excuse because you are not qualified to offer advice. In this case, you have to have a disclaimer that, please, I'm not advising. Sometimes there are instances I will say, this is not an advice. This is my opinion. This is what I would have done. You don't have to take it.
Mm-hmm.
So there are instances I draw the line, even though I'm qualified to give immigration advice. But what about somebody who hasn't qualified at all? Then it becomes even a worse scenario for that person if they put themselves in that situation. People know, but not many people know that it's an offense to do that. And so now that people are getting to know, or we refreshing our memories about the law, if you are not qualified, you have to be careful. You might be a law graduate, you might be a law student, you might have a degree in philosophy, whatever, anything. You might be able to read and write. You might be in university, but are you a lawyer? In the following categories: one, a barrister, solicitor, legal executive, or a practitioner regulated by the OISC, Office for Immigration Services Commissioner. If you are not, the law says you are not qualified.
Well, as Lawyer is saying, it's a criminal offense to provide immigration advice or services. In the UK, if you're not regulated otherwise, or otherwise qualified to do so, unqualified individuals offering such advice can face imprisonment and fines as specified in points A and B. We're talking about on summary conviction to imprisonment for a term not exceeding 6 months, or to a fine not exceeding the statutory maximum, or to both, or on conviction on indictment to imprisonment for a term not exceeding 2 years, or to a fine, or to both. This is based, as I said earlier, on sections 84.1 and 91(1) A and B of the Immigration and Asylum Act of 1999. So with that, let me, viewers, take you to the scenario that will form the basis of my um, quiz and test your knowledge bit when it comes to that at the tail end of the program. Peter is a law graduate. He has been advising people in his community on immigration matters. He takes up cases by completing and submitting applications for people, oftentimes for a little fee. In fact, on one occasion, he advised Sarah about an EUSS application and agreed to submit Sarah's application for her. Sarah's application was rejected because there was no reasonable ground for delaying an EUSS application until July 2025. Sarah has raised a complaint against Peter for the rejection of her application. So Peter is in a difficult situation now. Let's advise him. And I've got three options for you. Which one would you think would be the best to give to Peter? It is not Peter's fault that Sarah did not have any good reason for the delay in submitting her EUSS application. If Peter can show that he advised Sarah about the likely rejection, then Peter should be all right. Peter has committed a criminal offense and is likely to face imprisonment or a fine or both because he provided an immigration service when not qualified to do so. So I'm asking which of the three would be the best advice to give to Peter. Think about that. And when we come back to that at the tail end of the program, we will ask lawyer Charles Asma to give us which one would be the best advice to give him. So, stick and stay. Yes, Uncle Charles.
Yeah, so let's go back to the distinction between A and B so that viewers and listeners will have why 6 months and why 2 years. Why not just one? So
Okay.
A says on summary conviction, and B says on conviction on indictment. Summary conviction means if committed offense and that is it, it's an offense. You offer the advice, whether you did it deliberately or you didn't do it deliberately, it's an offense, and that we call it strict liability. So it's an offense. You are not qualified if offered advice. So this is to people who will say, oh, I didn't do it intentionally. I did it one-off. It is not something I do. But those who do it often and often and often and it has become a habit, then there is intention. And that is the indictable aspect.
Okay. Right. So yeah, thanks for that clarification and distinction. So in fact, it's still the warning and the clarification is that if you are not regulated or otherwise qualified to do so, don't do it. If you would want to do it, then there must be a disclaimer that you are offering an opinion or you are not asking them to compulsorily do it because you could land yourself in trouble. That's the advice. And I would advise you again that if you want to have somebody advise you on immigration matters, help you with your applications, your appeals, and all the rest of it, talk to BWF solicitors. Call them and book an appointment. See any of the lawyers, like Asma Esther, Eunice, Uncle Ben himself. We have Ani and all the other trainee solicitors in BWF solicitors. You can call them on 0208 493 734 493 7340. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. So climb up to the fourth floor of the Honor House and speak to BWF solicitors. Now this afternoon they're helping us to know very well and be aware that we can lose our money in our bank account if we are in the UK illegally. How do we safeguard our money? That is up for discussion next on The Community and the Law, brought to you by BWF Solicitors.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back. It's still the community and the law. And I know those of you who have joined us, you have registered your presence. We're live on BWTV at BWF Solicitors on Facebook, at BWF Solicitors on YouTube, and at BWTV UK, both on Facebook and YouTube. You can pick up the link and share with your colleagues, your friends, and people in your network. And then when you come on, please like the page and, of course, make your contributions known. You can send us a text with your question or concerns or contributions via text 07399208468. Or when the lines are active, you can call in on 0208 493 7345. You can leave your questions and your comments in the comment section down below, either on Facebook and YouTube at BWF Solicitors and at BWTV UK. Once again, my name is Enrico Ripon, and I have with me as my guest and resource person, Lawyer Charles Asma from BWF Solicitors. Uncle Charles, good afternoon once again. And
Good
now
afternoon.
into the main meal. You're telling us that we could lose all the money in our bank accounts if we are in the UK illegally. Is that true?
Yes, that is the position of the law.
That's my money. I need to keep it somewhere. It will still be in the UK economy. Why would I lose it?
Because the law says that any person who is disqualified cannot have an account in the UK. And so, if the money is found in the account, even though they put it there, it does not belong to them.
I find it quite strange and quite unfair. But you know the law, and there's always a reason why a law or a piece of law is put in place. Please unveil it for us. Let's look at the back end of the situation.
Sure. So today we are looking at a simple question. Did you know that if you are in the UK without papers or leave to remain, you could be an overstayer? You could have just come 6 months, but your visa is expired. In other words, you are living in the UK illegally without legal residence. Your money, if it's available in your bank account, can be taken. Did you know that? That's the conversation. The answer is yes. Even if you didn't know, it is the case. So, what are we seeking to achieve this afternoon? To let you know that the law is there, so that you know how to live your life as far as operating a bank account in the UK is concerned. If you are a disqualified person, so we look at the law for consideration, and we'll ask producer to take us to the law that will underpin our discussion for today.
Mhm.
So we are looking at the Immigration Act 2014. It's been amended, but this law is still valid, and this particular provision is relevant. So we go to the table of content and go down to 40, please. 40. 40.
Well, 40 talks about bank accounts, and we have 40, 40A,
Good.
40B, C, D, E, F, and G.
Very good. So 40 says that, Brako could read 40 itself for us.
So, prohibition on opening current accounts for disqualified persons. I guess we can expand that and go into the full text of that.
Yes, so let's
Um,
go to the full text. So,
can
producer,
we
that's what we
click
are
on the
going to be
link
doing
and get
today.
into in there?
Good.
Changes to
Very good.
legislation, as Lawyer has said, is giving a preamble to that. Uh, Immigration Act 2014, Section 40, which is up to date with all changes to be enforced on or before the 6th of September 2025. So it's quite relevant to today as well. 40, as lawyers asked us to read, says that prohibition on opening current accounts for disqualified persons. A bank or building society B must not open a current account for a person P who is within such section 2 unless A, B has carried out a status check which indicates that P is not a disqualified person, or B, at the time when the account is opened, B is unable because of circumstances that cannot reasonably be regarded as within its control to carry out a status check in relation to P. Should I
So,
continue with two?
yeah, let's pause and clarify section 40, subsection 1, sub section A and B.
Mhm.
So, B is being represented by banks. So, B here means bank, and P means the person who has opened the bank account.
Mhm.
So it says B cannot allow P to operate an account with B. So B must make sure that it has carried out status checks before allowing the person to open the account. So if something happens under section 40, it appears that B has a duty, that is the bank. The bank has a duty to make sure that before you open the account, you checked whether the person is qualified to have an account. That's agreed, right?
Mhm.
And B, the only mitigation for the bank for failing to prevent somebody who doesn't have papers to remain in the UK to have an account, the only mitigation is that they did everything they needed to do and they couldn't find out that the person was not qualified, and that's why they allowed the account to be opened, i.e. somebody opened the account for them, or the bank will have a reason why. That's why it says that unless B is able to show that it was unable to because of circumstances that cannot reasonably be what regarded as within its control. So if it is within your control and you don't take care, what we call care and attention, reasonable care and attention to assess and to verify before you open the account, you commit an offense. You, the bank, commit an offense. Then we go to two. Two is who is this person? So P stands for the person opening the account. It says the person is within this subsection if. So these are the people who cannot have an account with any bank. A, who should this person be? Brabeko.
Yeah, so this person is in the UK
Good.
and requires leave to enter or remain in the UK, but does not have it.
Full stop. So that's why section 440 subsection 1 says that B must not open a current account for person P who is within subsection 2. And the person within subsection 2 is somebody who is in the UK. So if I'm not in the UK and I get an account open in the UK, I don't fall under subsection 2.
Yeah.
If I'm in the UK and I have leave to remain, which is valid, I don't fall under subsection 2. Those who fall under subsection 2 are those in the UK who don't have leave to remain. In other words, they are illegal. And
Okay.
that's why the conversation says that if you are in the UK illegally and you have a bank account, be careful. Something can happen to it. We are looking at the context. So even if you get around it, you manage to open the account and it is found out. When we get to that section, you see that you can lose it. So these are the preliminaries. 3, what does it say?
Now, for the purposes of this section, A, carrying out a status check in relation to P means checking with a specified anti-fraud organization or specified data matching authority, whether according to information supplied to that organization or authority by the Secretary of State, P is a disqualified person. So B tries to define who a disqualified person is. So, lawyer, with your permission, I'll go to B. It says a disqualified person is a person within subsection 2 for whom the Secretary of State considers that a current account should not be opened by a bank or building society. So, opening an account for P includes opening a joint account for P and others, opening an account in relation to which P is a signatory or is identified as a beneficiary, and 3, adding P as an account holder or as a signatory or identified beneficiary in relation to an account. That's what 3 says.
Good. So, and this is very, very, very crucial. If you look at B, the beneficiary aspect, it could be your child who is under your account,
Mhm.
because some parents do that. The child will be under your account. So the account is in your name, but your child name is somewhere in there. That means the child is a beneficiary. Or you open an account and say that this account is for my child. Then we check to see whether your child is somebody with leave to remain in the UK. If the bank wants to stretch the duty, they can even extend it to cover the child. The fact that the child is not able to have an account open for them or for them to be a beneficiary of an account whilst they don't have leave to remain in the UK. So let's just for us to have a wider thought about the fact that it's not just about the individual, but it's also about individuals named as beneficiaries of the account and also individuals who are signatories to the account. A signatory to an account is an account that is a joint account. And a signatory to an account is an account that is for a body, a club, societies, companies, and so on and so forth,
Mhm.
churches. So imagine you have a club and society called All Joy Society. All Joy Society, what they do is people meet, they have fun, but they pay dues or contributions and they support each other. And they have managed to open account through somebody who has papers or leave to remain in the UK. But one of the leaders or executives potentially is not someone who is qualified. In other words, the person doesn't have leave to remain in the UK. But the person is an executive, so has become a signatory and they manage for the person to sign as a signatory. Is that an offense being committed somewhere?
Yes, because the person is not qualified to do it.
To sign, to be a signatory to the account.
Yeah. You
So
see,
if you're a
when you
signatory,
go to 3C, um,
yes,
3C and subsection 2, opening an account in relation to which P is a signatory or is identified as a beneficiary. So obviously, you can't be a signatory to that account if you do
If you
not
don't
have
have
permission to stay
leave
in
to
the UK.
remain. Very good. You remember, you know that a lot of us don't think beyond the fact that I am the main account holder.
Mm-hmm.
And that is letting us know that even if you are not the main account holder, but you are a signatory or you are a beneficiary, you are as bad as the main account holder.
Mm-hmm.
And the bank will have to do all these checks before the account can be opened. The bank can say that, well, we didn't know that one of the signatories wasn't, but the bank is supposed to have an inspection carried out. But for whatever reason, the bank has a mitigation under Section 41 B, which says that if you did everything possible within your control and you couldn't find out and the account was opened, you have an excuse. But then the person themselves or those persons themselves will have to answer for it. Let's go to 4, please.
In subsection 3A, anti-fraud organization has the same meaning as in section 68 of the Serious
All
Crime
right.
Act
So
of
we pause here. We pause
yeah.
it. So this bit is all about money laundering, washing up, and all those things. People who are able to, much as they want to prevent money laundering and people bringing money which are not legitimate to the UK to have it in a UK bank account. It's also about who qualifies to open an account. So we are today interested in opening an account, using running the account whilst you are not qualified to do so. Right. Now let's go to 6. That is so a bank or building society. Yeah.
So it says a bank or building society that refuses to open a current account for someone on the ground that he or she is a disqualified person must tell the person if it may lawfully do so, and that is the reason for its refusal. So I want to take it again. A bank or building society that refuses to open a current account for someone on the ground that he or she is a disqualified person must tell the person, if it may lawfully do so, that it is the reason for its refusal. So they are
Okay.
telling you we can't open for you because the law says we shouldn't. Is that not what he says?
Exactly. Simply the bank must tell the person that they cannot open an account for them because they don't have the right to remain. And we know that the essence of the share code is to tighten up those things. So now the banks will ask for your share code to be able to link you to your visa
Okay.
as part of the controls. Right. Now let's go to
No, you
so
just mentioned share code. If I could ask a question on this one. Um, the share code, the one we generate to look for employment, is it the same we are looking for here? That same share code, maybe by extension, is the same share code we give to our landlords?
so we have 4 categories of codes. Code to show immigration status. That is called immigration status share code.
Mhm.
Code to show your right to work. That is called employment status or right to work share code. And that goes to employers.
Mhm.
Immigration status goes to everybody, including immigration officers.
Okay.
Right to work share code goes to employers. Then we have right to rent share code. That goes to landlords.
Okay.
And we have right to open a bank account or borrow lending purposes. That goes to the banks and
Banks.
building societies.
So if I'm granted limited leave to remain here in the UK, for instance, would I be allowed to generate all these 4 share codes?
Depending, so they will always ask you, what do you need it for? And you have to specify and narrow your request to that purpose.
Okay. All right. Well, folks, we're looking at the topic whether you were aware that you could lose all the money in your bank account if you are in the UK illegally. And Lawyer Asma from BWF Solicitors is taking us through that. And he has really opened us up to the law and what the law says, who the banks should open a bank account for. And we have defined B and P, B being the bank, and P being the person that's looking to open a bank account. And the qualification criteria has been given, or disqualification criteria, if you want to put it that way, have been given. And we would want to really go a step further in the discussion. Remember, it's still the community and the law. It's brought to you by BWF Solicitors. Those of you on the platform, I would want to recognize you. Junior Marvin, thank you very much for being here. Minat Ghana, you are here. Tilly Duma is, as usual, online. Hello, lovely family. We also have Isaac Tete, who's joined us. Thank you very much for watching with us. Mame Abuajiwa Wusu, you're watching. And we have Francis Chairman. Francis, yes, you put in a question. We'll come to that when we have dealt with the main discussion, so don't you worry at all. We also have Adair Taribo online, Minat Ghana, Francis Chairman, all the other ones I have mentioned you. Nanajima says very important, an amazing topic. Please share, 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 and share. That's the mantra for this afternoon. We're looking, again, I want to repeat that. Did you know you could lose your money in your bank account if you are in the UK illegally? We will just remind you of our social media platforms. And when we come back, Lawyer Charles Asma will continue with the discussion further into the next step. Well, thanks for sticking around. The community and the law brought to you by BWF Solicitors. 0208 493 7340 is their telephone number. This afternoon, our resource person and guest is Lawyer Charles Asma, and he's taking us through the topic. Did you know you could lose your money in your bank account if you are in the UK illegally? Lawyer Asma, yes. So we've looked at the definitional issues. We looked at what the law says. Um, what else do we need to know?
Right. So we're now moving on to, so section 40 is to do with the banks, what the banks must do.
Okay.
Let's go to section 40A. So section 40 is categorized in up to G. So let's look at A. Producer, take us to the authority. Yes, so A, 40A. If you go back to the content and 40A. Okay,
So
A.
40A, as it were, is looking at requirement to carry out immigration checks in relation to current account. With your permission, I'll read on, Lawyer.
Yes.
It says a bank or building society must, at such times or with such frequency as is specified in regulations made by the Treasury, carry out an immigration check in relation to each current account held with it that is not an excluded account. For the purposes of this section, carrying out an immigration check in relation to a current account means checking whether, according to information supplied by the Secretary of State to a specified anti fraud organization or a specified data matching authority, the account is operated by or for a disqualified person. So I think it goes back to those definitions we looked at earlier.
Yeah, yes. So now go back to number one. What do we mean by they should carry out checks? How often? How long? When? What does the law say?
Mhm.
A bank must. This is
At
compulsory.
such
Must.
times or with such frequency as is specified in regulations made by the Treasury.
Full stop. So let's leave it there. So what it's simply saying is that the banks must, from time to time, do checks or carry out checks. And we don't know when such time will be, whether it's going to be every month. So some banks will do it every month. but that would be too tedious. So they may do it every quarter. Some may do it every 6 months, but it will never be every year because that would be too late. So they will do it frequently. So we don't know the frequency, and therefore the bank will do something. You just have to put yourself have it in your mind that if you're a disqualified person, the bank can do it at any time. So we might have two people. Somebody may have a letter today. The friend or other person might never have any letter at all. Then you say that how come you got it but I haven't gotten it? We don't both have papers. So what's going on? Because the banks are different, the checks are different, and it's a spot check. So call it sampling. They will sample the name and match the name. And once, like a lottery, once your name is picked up and it matches that you don't have papers, then your account is activated for action. So it's not everybody at the same time, but everybody at some time. And so you can't say, what about me? What about him? Somebody had it. I didn't have it. It doesn't really matter. It is you once you are picked up. And you'll be picked up once the bank carries out such sampling checks and matching those accounts they have on their data or on their in their books. They match those accounts. So they can sample like 1,000 and match them against Home Office database, which they have access to.
Okay.
Then something will flag up and they know that these are the ones we are going to be dealing with now or at that particular time. So that is how it happens. And the authority is under Section 40, capital A, subsection 1 of the Immigration Act of 2014 as amended. Okay, let's pause and go to, so that is 40A. Let's go to 40B. Producer, 40B.
Okay. So we'll go back to the table of content and pick up 40B, which is also some requirement as well. And it says requirement to notify existence of current accounts for disqualified persons. And with lawyer's permission, I'll continue to read. It says this section applies where, as a result of an immigration check carried out under Section 40A, a bank or building society identifies a current account that's operated by or for a person who the bank or building society believes to be a disqualified person. I have my own question here, if you would permit me to ask.
Yes, go ahead.
Yeah, the 40B1 is saying that the bank believes that the person is a disqualified person. So if out of the blue they suspect me, they are required by law to carry a check on me.
It says that this section applies where as a result of the check carried out, so it's not out of the blue. As a result of the check carried out under 40 capital A, a bank now holds a belief.
Okay.
So the belief is informed by the checks.
By the check, okay.
That somebody who doesn't qualify has an account with us.
All right. I asked that question because probably somebody in the bank would see my name, Oreku, and thinks that Oreku, I suspect is Oreku. Then they go ahead to carry out that. It must be informed by something, a precedent, isn't it?
Yeah, I agree. It must be informed by but the thing is, you see, sometimes when people come to us or come to me and they ask, lawyer, will the Home Office write to me? Will the Home Office do that? I tell them that, look, see how busy we are. They are even busier. So if it's not necessary, they won't waste time and money and effort.
Okay.
And so it won't be out of the blue that they will go fishing for names that sound foreign. No, they don't have. And most of those people working at the bank also have foreign names anyway. So it will be so they won't do that. But they have to carry out the checks. So it's a matter of when you have won a jackpot with the bank. If I say you've won a jackpot, once they carry out a sample and your name flags up after they have checked with the Home Office database, and your name flags up that you are a person who has no leave to remain in the UK, then you have won a jackpot, then they will deal with you. So pray that you don't win. Simple.
Well, 40B1 is what we are discussing now. Let's see what 40B2 says. And lawyer says where this section applies, the bank or building society, as the case may be, must, as soon as reasonably practicable, notify the Secretary of State that the current account held with it is operated for or by a person who it believes to be a disqualified person, and then B, provide the Secretary of State with such other information as may be prescribed. So, is it saying that immediately they find out that you are a disqualified person, you should be reported to the Home Office?
Yes. So one, carry out a check, and two, whatever you find which is in the interest of the public, tell the Home Office. So when you find that the person who has an account with you is not qualified to have an account, tell the Home Office. So the banks have a duty to do that. If they don't, then they are in breach of 40B. Then Home Office will deal with the individual. It is not up to the bank to deal with the individual. The Home Office will then proceed to notify the individual. So go to 3. What does it say?
Now, 3 says a notification made or information provided under subsection 2 must be made or provided in the prescribed form and manner.
Well,
I think
we don't have
4
to.
continues to tell us what the prescribed means.
Yeah.
And it says in subsections 2 and 3, prescribed means prescribed in regulations made by the Treasury.
All right.
Regulations under subsection 2 may, in particular, require the provision of information relating to any accounts held with a bank or building society that are operated by or for the person who is believed to be a disqualified person.
To be fair, we don't have to be worried about how the bank will report because it's not our business.
Mm.
And so I wouldn't want to bother the prescription for reporting because it is not the individual who must report. And I'm talking to the individual who may not be qualified. So it's not your job to find out how would they report. Your job is to make sure that once they report, Home Office will write to you. So be prepared. That's all. So let's not worry about how the bank will report, but they have a form they have to fill and provide the details. And the details will be the name, the status of the person, and any other information that the Home Office database will make available to the bank. Because the banks will have access to the database. So the banks have access to HMRC database, Home Office database, and some other relevant database. And that's why they are able to sample and cross-check what they have against the database information.
So when they report to the Home Office, for instance, lawyer, what then happens? Is it where the bank duty ends and the Home Office, as you mentioned earlier on, that the Home Office will have to deal with the person? What happens to me as a disqualified person?
Good. So we are going to use the next 10 minutes, just go through quickly, then we'll look at a sample of how the Home Office will act, and we'll open the conversation up to the public. So let's go to 40C. Producer,
So we got to
40C.
40C, and 40C is also talking about what follows A and B. Action to be taken by Secretary of State following Section 40B notification. Where the Secretary of State receives a notification from a bank or building society under Section 40B2 in relation to a person, the Secretary of State must check whether the person is a disqualified person. If the Secretary of State determines that the person is a disqualified person, the Secretary of State may apply under Section 40D for a freezing order in respect of one or more of the accounts held with a bank or building society that are operated by or for the disqualified person.
Good.
Now it continues in 3 and says that if the Secretary of State decides not to apply for a freezing order under subsection 2 or decides to apply for a freezing order in respect of one or more, but not all the accounts held with a bank or building society that are operated by or for the disqualified person, the Secretary of State must notify the bank or building society that it is subject to the duty in Section 40G2 in relation to the disqualified person.
Right. Yeah, so let's leave it there. The rest is just formalities. So here, So Secretary of State has two actions to take. One, they have to make an order to the court to freeze the account, and that's called freezing order. They can also choose not to go through that process. Go straight to the point and tell the bank that this is the case. Stop running the account and give the money to the state. So these are the two options the Secretary of State has. You can see that one is a longer process and the other one is quite straightforward. So which one do you think the Secretary of State will go for?
Well,
Exactly. Unless it's contentious, that is when they will go for freezing order. But if it's straightforward, normal account, few pounds in there or few thousands of pounds in there, no controversial or complicated, they will straight away tell the bank to close the account and keep the money or transfer the money to the treasury. Right.
now,
Obviously,
if the Secretary of State decides to get you to, or to get the bank or the building society to freeze the money, freeze obviously, put it somewhere, it won't generate interest or it won't be used for anything. Could there be a situation where you could get your money back?
that is why. So I remember I said that if it's complicated or contentious, then it has to go through the court process. So it becomes a litigation matter for the Secretary of State and the individual who is perceived to be disqualified. And disqualified could even be a company that is operating in the UK illegally, because it could also be an artificial account holder. So that aspect is there. But the second one, which is for viewers and listeners who are with us today, most people will fall under 40G, where they won't go through the freezing because the amount may not be too much, might be few £1,000s, 10,000, 15,000, 20,000, or even less. Then they'll take a shortcut and operate under 40G. So we are going to look at 40G procedure, if that's okay.
Yeah, that's fine. So
So
let's pick up what 40G is saying. Closure of accounts, uh, not subject to freezing order.
So let's
Yes.
pause here. So you know that we didn't touch 40D. We jumped from C to G, right?
Hmm.
Because D is the freezing order, which we have explained already.
Okay.
So we skipped D. We also have skipped E, and we are at G. We'll go back to E as soon as we finish with G. But G is what the bank must do if it is a straightforward matter. What should
Okay.
they do?
So this section applies where a bank or building society makes a notification under section 40B2 in relation to a person. Then B says the person is determined by the Secretary of State following a check under 40C1 to be a disqualified person. And then C also says that the bank or building society receives a notification under 40C3 or 40D7 in relation to the disqualified person. Where this section applies, the bank or building society must, as soon as reasonably practicable, close each account held with it that, in the case of a notification under 40C3, is operated by or for the disqualified person and is not the subject of an application for a freezing order. And B, in the case of a notification under 40D7, is operated by or for the disqualified person in respect of which a freezing order is not in force. Should I read the three?
Okay, let's finalize with three and
Okay, so the bank or building society may delay closing an account which it would otherwise be required to close under subsection 2 if at the time at which it would otherwise be required to close it, A, the account is overdrawn, or let's scroll a bit down for me, please. Overdrawn, or where the account is operated by or for the disqualified person and one or more bodies or other persons, the bank or building society considers that closing the account would significantly adversely affect the interests of any of those other bodies or persons.
good. So it's clear that Once the bank decides not to go through the freezing, Secretary of State decide not to go through the freezing order under 40D, they will notify the bank to take action to close the account under 40G. Here, the bank will have to immediately do it. The only time the bank cannot do it immediately is when the bank is useless, the account is useless. What do you mean by the account is useless? The account has zero balance or has negative balance. So what's the point closing it? That's point one.
That's very good. Yeah.
Point two is where the account is joint and there are other people who are not disqualified persons. And that's what I was explaining. The person might be a signatory and one of the signatory is disqualified, but the other is not disqualified. Will you then punish everybody simply because there's one bad nut? It becomes contentious because the other parties have their right. They are not disqualified. So how do you draw the line and apportion punishment? You see, and that is why it says that where these factors are present, delay closure until processes are complete.
Okay. Well. You said we were going to go back to D and E.
So look, that we won't touch D because D is the court process, which most people don't need. Because the monies to be the account we may only have maybe up to 20,000, 30,000, 50,000, and may not be too complicated or contentious. So let's go to E, 40E.
So let's look at 40E and talks about the freezing orders. An appeal may be made to the relevant appeal court against a decision of a court under Section 40D. The right of appeal under subsection 1 is exercisable by
right. Okay. So yeah, Brakuku. I think E, D, E, F all talk about the freezing process. Okay. So let's not burden ourselves with that because that is when the matter is going to court. And if it has to go to court, you will know that you have been given right of appeal once the account is to be frozen. So that is, but we're looking at closure immediately. So G. Let's look at an example of where the Secretary of State has acted on the information of the bank once the account has been flagged. Producer, if you're available, can you share the second resource with us? And I think it's fully redacted. There's no data protection subject matter here. All right.
Okay. So this one talks about why your account has been closed, and the Home Office is giving a reason for that. And it says, Home Office records indicate that you do not have permission to stay in the UK. Under Section 40G of the Immigration Act 2014, as amended by the Immigration Act 2016, the Home Office has notified your bank or building society that it is under an obligation to close an account operated by or for you. Any application or appeal submitted after receipt of this notice will not automatically affect the decision to close this account. What are your next steps? If you don't have any valid basis to legally remain in the UK, you should make arrangements to leave as soon as practicable. Failure to do so means you'll be subject to an enforced removal by the Home Office. The voluntary return services can be contacted for help and advice on leaving the UK. They can explain.
Let's go to the decision itself. How to challenge the decision.
So, how to query this decision? If you believe you have been wrongfully disqualified from operating an account, you should contact the Home Office by calling the number on the screen 0300-123-4979. You can also contact the Home Office by visiting that link. That's the .gov.uk guidance, where you ask the Home Office to check your immigration status is correct. If you wish to make a complaint, you should do so by sending an email to the complaints department, complaints@homeoffice.gov.uk, or write to them at the address on the screen, lawyer.
So let's leave this information on the screen. How to query this decision. So the Home Office, through the information from the bank, has notified you that the account you hold with that bank is closed. Before they get to this point, the bank has done everything and they are just acting within the rules. But you also have a right, and so they give you your right. How do you query this? They say if you believe that you are wrongly disqualified, then tell us so that we can reverse the decision. Question is, how do you tell them that you have, in other words, if you believe that you have papers and the bank thinks that you don't have papers, then come and show us your papers. That's the interpretation.
That's the interpretation. Okay.
So, how do you then reverse a negative status to a positive status, which will support your challenge of the claim that your account should not be closed because of your change in circumstance? What it means is that it's possible that from the time the information was picked up to the time you were written to with this notice,
Mm-hmm.
you have become legitimate.
Okay.
It's possible, right?
Yeah.
Or you are in the process of becoming legitimate. It's also possible.
Mm-hmm.
You have become legitimate means that you have now been issued with leave to remain. So you are no longer disqualified.
Yeah.
You are in the process means that you have put in an application with a view to getting a leave to remain. And so you cannot, at this material moment, be deemed to be disqualified.
Yeah, because obviously the decision has not been made on your application. Yeah.
Very good. And so, on that basis, you can use that to fight back to say that, yes, I was, but now not, or now I'm expecting. And so, my account should be open until I become disqualified again.
Okay.
Then you can fight back with that argument.
Now, so when you fight back, it would be on the premise that at that point the account is frozen and you haven't lost your money. Could that be correct?
So that once the account is closed, the money is no longer yours. You don't have access to the account that is closed.
Mm-hmm.
The question is, why didn't they give you your money? Because the money is being taken as well. How do you get the money unless the account is reinstated or reopened?
Okay.
So your job is to get the account to be reopened by becoming qualified. And I'll give you two scenarios.
Okay.
In 2022, I was dealing with an application. The person had been in the UK for 20 years. So we were in the process of applying. It took some time for him to gather the evidence. So put in the application. Whilst he was waiting for decision, the decision took about a year plus. He came to me to show me a letter under Section 40 that the Home Office has written to him to say that his account is closed and the money is kept, and so he cannot access. He needs money to buy food he can't access, and he was just stranded. So I told them, let's see the date. And the date indicated that at the time the notice came, the application was pending. So I told him, right, you can go to the bank and tell them that you have an application pending, the decision hasn't come. And so they have to look into it. The option was for a lawyer to represent him, but obviously it was going to cost money
Mm-hmm.
for him. So I gave him options. So he went to the bank, speak to them, and they reinstated. And he came back and said, oh yeah, after some weeks, they have got he was written to say, why should we not? Just like this one.
Mm-hmm.
So he was able to get the account reopened and he had access to the money, everything. I think at that time he had about 60,000 or so in the account. Now, for him, they also picked some things up as to regular transactions, sending money to different people, huge sums of money. So, an issue of money laundering consideration came up, but he was able to deal with that. This one on the screen came to me, I think, about last week. And the person is now organizing himself to put in an application. So currently he's disqualified. He doesn't have papers. So he showed me this. and I have discussed with him what he should do. That is not to be shared here. But all I'm saying is that these are some of the things he can do. And the moment they say this, it doesn't mean that that's the end. They will give you right to do something, and your job is to act immediately.
So, Laura, I maybe for clarification, is there a difference between when they freeze your account and when it is closed totally? Now, in between, or when you are faced with either of those situations, does it mean that the story is ended and you can't do anything? Or when it's closed, you can't do anything? When it's frozen, you can do something? What would be the difference?
Right. Remember, under 40D, it's a gateway to 40E. D says that freezing can happen. E says that once freezing has happened, you can appeal. And F specifies the approach. So, under freezing, remember it's a court process,
Mhm.
and there should be procedural fairness under the Administration of Justice Act.
Mhm.
So, if you are freezing my account based on a claim, then you must give me opportunity to put in a representation or a challenge or a rebuttal. And so they will give you right of appeal, and that can take a long time. Freezing simply means that it's been placed on hold.
Yeah.
So you cannot access it until the process is over. Once the process is over in your favor, you have access back. Once the process is over against you, you do not have access back. Under G is closure. The account is closed. Normally, when an account is closed for any other thing other than disqualification under immigration rules, you would be asked to come and would take your money, right?
Mhm.
For example, you are operating the bank account haphazardly, and they are not able to tell where the monies have been coming from, blah, blah, blah. They will tell you that we are thinking of closing your account. So by this date, make sure that you tell us where we should send your money to, and they will give you your money back and close the account. But where there's closure under disqualification under immigration rules, Section 40G of the Immigration Act of 2014, as amended in 2016, then is closure. Unless you are able to give reason why they have to open the account for you to access the money, you cannot have the account reopened and you cannot have the money back because you don't qualify to have the money. You are disqualified.
I have a scenario, lawyer. Those of you who are watching us, you can send in your questions or your concerns to the text number 0739920848, or you can leave them in the comment section down below, either on Facebook or YouTube at BWF Solicitors and at BWTV UK. I am living in the UK without permission, or I'm illegal, but I have a child I am taking care of. I do not have access to public funds, but I've managed to get some money and I've put in an account where I am able to transfer money and use those resources or that amount of money in the account to cater for a young person in the UK. Would that be reason enough to say that they do not have to close my account?
Well, so we have Section 55 of the Borders Act.
Mhm.
There's also Section 1 of the Children Act of 1989. Section 1 Children Act talk about best interest decisions. Section 55 of the Borders Act talk about best interest decisions from immigration point of view.
Mhm.
There's also a case law and so many other aspects. But if we look at Section 6 of the Human Rights Act of 1998, it says that a decision by the government which contravenes the Human Rights Act itself, i.e., any of the articles, say Article 8, for example, right to family life, then that decision is not lawful because
Mhm.
it is infringing upon a human right. Question: opening a bank account whilst you don't have an account and using the money in the account to look after your child, is that a human right?
Well, if I don't take care of a child, the child will suffer, go hungry, may not have their
No.
basic needs.
This is a yes or no. Then you tell me. Then we'll look at the
Well,
reason.
to me, I would say based on those one, the premise I was giving you, I would say it's a human rights issue.
But I mean, so is it your human right to operate an illegal account just so you can look after your child? You can't use illegality to do legality. And so, no, it's not a
Okay.
human right. But you can plead on mitigation grounds that, yes, this is the case, but in the interest of my child, can you let me have the money whilst you close the account?
Okay.
Then you're asking for them to give you your money as if you had papers, but you were using the account for different purpose. So they want to close it. It's their right to close the account because it is their account for you. But if you don't have papers, they must keep the money. But you need the money to look after your child. And if they say no, then you can rely on Section 1 of the Children Act of 1989. You can rely on Section 55 of the Borders Act. And you can rely on case law to say that it is not in the best interest of the child to keep my money whilst you close the account, regardless of my punishment. Then it becomes a matter for consideration whether they have to make a favorable discretion in the interest of the child. But on the balance of probabilities, they are not wrong to say no. So you can only plead for them to consider. So to answer your question, no. But can you plead? Maybe they may consider. Now, how do we get around this? This
Mhm.
is somebody who has a child. Let's assume that this child is a qualifying child under Section 117D of the relevant statute, in that the child's father is British, in that the child's father has settled status or indefinite leave to remain, and the child was born by the operation of Section 1 of the 1981 British Nationality Act. Then the child is British by operation of law. Maybe the lady or the mother didn't know that she had a qualifying child. In this case, she puts in application having now known that she qualifies to apply per her parental relationship with a qualifying child. She makes an application for leave to remain under Appendix FM. Then the query is, if you have ceased to be a qualifying child, a disqualified person, then
Mhm.
we can consider. My argument for my client will be that prior to the decision, my client was disqualified. Post decision, my client has become um, qualified because
Qualified.
she has an application pending. And so, on the basis of that, the account should be reinstated to the point a decision is made when she becomes disqualified again. That's first argument. The second argument will be under the best interest argument for the child. Now, whilst they are waiting for decision, the child needs to be fed, and this is the source of money or fund support for the child. And so, in the interest of the child, they have to consider and make a positive discretion. On a balance of probabilities, they may consider favorably.
Well, if you just joined us, we're discussing whether you knew your money in your bank account could be lost or be taken off you because you are not in the UK legally. Largest Asma from BWF Solicitors has shown us what the law says, things we can do to go around it, how we can mitigate the situation, and then also to get our monies. You have the chance to call us 0208 493 7345. I have Prince Owusu saying that this is very timely and very important topic that's being discussed today. So yes, Francis Sherman also has a question we're going to go at The lines are also active 0208-493-7345. We're still on the community and law and it's brought to you by BWF Solicitors. Our resource person and guest is lawyer Charles Asma. So straight away we'll go into your questions. And remember, I have my nugget and the quiz competition we're going to be looked at. So please bear that in mind. So, lawyer, with the permission, let's take some of the questions that have come through.
Sure.
Francis Chema is saying, is it possible for a Ghanaian man who is in the UK to marry an Italian woman also in the UK in Ghana through proxy marriage?
Right. So this is what I usually discuss with my client when they come to me to say that they have they are in a relationship and they are planning to get married. Can they marry under their country's customary marriage processes? Because proxy is a customary marriage, and this is Ghana, so it will be under the 1985 Customary Marriages Act of Ghana, Section 3 says that after the marriage, parties, one of them or both of them, can register their marriage at the registry. And family members who witnessed the marriage at home can sign a statutory declaration affirming the same. They go to the Ministry of Foreign Affairs to get a confirmation that their signatures are valid and also the Judicial Service for same. Question: statutory declaration by who? Family members, right?
Mm-hmm.
Now, a Ghanaian, an Italian woman. We don't know the origin of this Italian woman. So I take it that this is an Italian woman who has no root in Ghana. If this Italian woman has no family root in Ghana, who will be the person to represent her at the marriage? Because there should be a representative for both parties. Who's going to represent this Italian woman in Ghana during the marriage ceremony? And who will be signing the statutory declaration to say that they represented the woman? And what will be the relationship? If it is the case that the person, this partner, has nobody in Ghana, would they be able to register the marriage under customary marriage rules?
No, because they don't have anybody.
One has. The man has people, but the lady doesn't.
Yes, the lady doesn't have, the man has. So, as you said, by law, one of them can pick it up and register, isn't it?
Yes. So we said that by law, one of them will say, I want to register, but both must have a representatives
Mm-hmm.
for the registration and for the marriage ceremony itself.
Okay.
And that's why the statutory declaration, one will say that I am Kwesi Mensah, the uncle or Ebusuapeni of Adrian Mansa, who is the party to this, or the spouse or the wife or whatever.
Okay.
And the other will say the same thing for the other one. But this Italian woman, who is going to be saying that if indeed she has no root in Ghana? And so I do advise people, once I take them through this journey of thought, they say, oh, lawyer, okay, I now get it. I didn't say anything, but they get it. That if the person doesn't have a root in Ghana, how did they get somebody to represent them at the marriage ceremony and the registration? And if I'm a case worker at the Home Office, I want to know the origin, I want to know who the parties are, and whether they have any root in the country they claim the marriage took place.
Okay.
So I think, Brother Cool, the person wanted to hear yes or no, but I couldn't say yes or no. But from what I have said, it all depends. If they both have reps, then yes. If one doesn't have any family and so nobody to represent, then it will be difficult.
Okay. All right. Thank you very much. But if you really need any further clarification or any further discussion on that, you can call BWF Solicitors 0208-493-7340, or you can get in touch with Lawyer Asma. Let's give you Lawyer Asma's number 07947 63 60 37. 07947 63 60 37. Let's pick up the next one from the platform as well. Could you Boateng from you are on YouTube at the moment? Do I need a transit visa if traveling from Ghana to the UK with Ghana passport or vice versa, Turkish airline or any other European airline? So I'm assuming that you're traveling from Ghana to the UK, you are going through Turkey, for instance, Istanbul, for instance. Do I need a transit visa? Laura?
Um, so please don't quote me here. I have to verify. But as far as my memory will serve me right, and
Mhm.
please, I'm saying this with caution. As far as my memory will serve me right, it appears that if you are resident in the UK, you can go through the transit process in any European country. But we have to verify.
Okay. But this I assume Kojo is asking, the person is traveling from UK to, okay. So if you're a resident of the UK, that's what you're saying. If not, I guess
It
for
says that
to be on
I
the safe
need.
side, find out.
No, I think Kojo says, do I need a transit visa if traveling from Ghana to the
To UK,
UK?
yeah.
Right. Okay. So it's not like he's going on holiday from Ghana to the UK with Ghana passport on visit. Right, Kojo. Okay, we now get your story. Thank you so much, Brakuku, for revisiting the story. Visitors visa, Turkey, speak to the Turkish airline or any other airline you want to, because there are restrictions for certain type of visas.
Okay. All right. Yeah. So obviously, could you ask and uh, if you booked through a travel agent, ask them to ask the airline for you whether you would need a transit visa. Um, Good afternoon, lawyer and Kwaku. I have two questions. One, a friend of mine was banned for 10 years for using fake documents in 2017. He's now married to someone who settled in the UK. Can he apply for a spousal visa to the UK? The second one says, can a pensioner who is on pension credit bring his wife to the UK? He does not earn £29,000 or above. So can they do that? Let's pick up the first one first, lawyer.
Right. Yes. So the first one appears to uh, be like content of a case that I handled, um, where this person, that is the case I'm talking about. This person was in the UK, went to prison, and was deported. Has been away for more than 10 years.
Mhm.
So the 10 years ban or order has been served. Then the the person married a British citizen, had a baby, and want to visit or reunite with the wife. The person was refused. We also had to go for revocation of the order because the deportation order needs to be revoked even after 10 years. So we went for the revocation order, and again it was refused. So there were two refusals: refusal of the revocation order, the deportation order, and also the refusal of the family life application to enter the UK. We had to go to court. It took 6 hours at hearing, but we succeeded by the grace of God.
Mm.
So that is one angle, and that tells me that this is also possible. However, we have to look at the circumstances. This person was banned for whatever reason, I'm sure under paragraph 9.7.2 of part 9 of the rules, was banned for using fake document. Yeah, he says it. 2017. So let's count. 17, 18, 19, 20. So it has to be expiring in 2017, 2027, right?
Mm-hmm.
2027. So
2027.
on the face of it, he's not due to come to the UK. On the face of it. However, on the face of Article 8, which is human right, family life to a British citizen or with a British citizen, do we say that he's being banned and he stays away, or his human right will take um, preeminence or will take over the punishment for waiting for those how many years more, 2 years more. It appears that once he applies for leave to join the spouse, it's likely he'll be refused because the rules say that if you are banned under 9.7.2, any future application will be refused under 9.8.1, 9.8.2, 9.8.3 of Part 9 of the immigration rules. And so the caseworker will just apply the rule and say refused. He may go to court and argue on a point of human right, saying that Section 6 of the Human Rights Act has been engaged because the decision to prevent him from joining the wife is an infringement on his Article 8 human right. And so the court should look into it. And that will be a matter for the court to determine whether somebody who has human rights whilst there is a ban in place should be considered for the human right to take over the punishment that is still in force. So
Now,
that's
there's a
answer.
second question, which is about a pensioner who's on pension credit, wants to bring the wife to the UK. He does not earn 29,000 or more.
Well, the rules say that if you are on disability support, what we call personal independent payment,
Mhm.
and other qualifying packages or support, then you don't have to meet the 29,000. But again, the person wants to bring a spouse to the UK, which is human right application. They don't meet the rules. So it appears that EX1 of immigration rules and EX2 will come into force where there are exceptional circumstances. And the exceptional circumstance will be that they don't qualify for they don't meet the maintenance, the financial threshold. However, they have human rights. What should happen? If they say no, they go to court. But on the face of it, they must meet all the rules. But where one is not met and they want to rely on their human right alone and rely on the exceptions to the rules, then they can put in an application and see what will happen and seek redress from court.
We're live on BWTV at BWF Solicitors Facebook and YouTube, and at BWTV UK Facebook and YouTube. You leave your comments in the section below. Prince Osewusu Stan, if the account is frozen, will the bearer of the account holder be notified on time, or would it be closed immediately after being disqualified? If a disqualified individual finally secures a new status, will their account be restated or activated for full operation? How many months does an individual need to accumulate before traveling overseas? I think that's um, more of a different one from the two paragraphs above. But let's look at the account being frozen and how you get it back when your status has changed.
Okay, so once the account is, it says, will it be closed immediately after being disqualified? You already disqualified, so it's not that you are being disqualified. You have been identified as disqualified, so you were already disqualified, and that would trigger the closure under Section 40G of the Immigration Act of 2014 as amended 2016. Now, it says the holder is notified on time. What is on time? On time could be any time, but you have to be told first before the closure can take place. So yes, you'll be notified. And we saw the example where the person has been notified and has been given option what they can do. So once you don't do anything, then it is concluded that it's closed. The next one is disqualified individual finally secures that if will this be of course. So we said again depends on the time. If it's going to take you 1 year for you to have a new status, the account is closed 1 year ago. So I don't think you can have it back. So the earlier the better. Delay defeats equity. That's the one of the maxims of equity. And so make sure that if you are going to be acquiring a new status, immediately put in the application and rely on that to make a request for reinstatement. And the third one, How many months does an individual need to accumulate before traveling overseas? Who is this individual? Somebody who can travel and come back. If you can travel and come back, you can go on holiday and come back in. If you have limited leave to remain, you have to come back within 6 months. If you have indefinite leave to remain, you can stay away for 2 years. So if you have British citizenship, then unlimited. Those are the circumstances.
Those are the circumstances. Let's pick the next one. Then we'll go on to our nugget and quiz again. Um, Eminent Ventures, I did apply for indefinite leave to remain under EU family for my children because me and my wife have now gotten indefinite leave to remain. There were three of them, three there were three. One of them was giving the indefinite, but two were not given. The reason is they do not have leave UK for 5 years. Meanwhile, all the three children came the same day. Can I reapply or wait till the 5 years before I can apply for them?
Honestly, yeah, before it was automatic that a child under 21 will be given the same status as the sponsor. So if the sponsor had indefinite, the child would have been given indefinite. But now it's changed. They are relying on the fact of residence, that 5 years residence before indefinite, regardless of age. And so most children are being granted pre-settled, whilst we thought they would be given settled. Should I apply again? Well, you can apply again. Let's see if there will be a jackpot. Remember, three children. Some were successful, some were not. What it means is that it depends on the caseworker. But should it be dependent on the caseworker? But the question is, if the rule says that you should be 5 years before you be given indefinite, then all of them should have been given pre-settled. Why is it that one was given indefinite? Is that a mistake? But that is a favorable mistake, so you don't want to talk about it. So you see how the dynamics are. And so I would say that the default is they will give pre-settled. If you are lucky and you get settled, obviously they've made a mistake in your favor. I don't think you have to fight a favorable mistake. But if it's a genuine application of the rule for 5 years, will you challenge it? Should you do it again? Yeah, try again if they will make another mistake to give the child indefinite. And should it be the same day, or can I apply or wait 5 years? So the standard is that you wait 5 years. But if you can do something to get it earlier, I don't know what you would do, but it's your call.
Well. Thank you very much, Lawyer Asma, for taking time to answer the questions. This one has been slipped through, so we'll do that quickly before we go on to our nugget and quiz. Myself and my wife are here in the UK. Can we file for my stepson, whose father is late, to join us? If yes, who will he be traveling after? Myself, the main applicant, or my wife, the dependent?
Okay, so myself and my wife are here in the UK. Can we file for my stepson? So this is the wife's child, whose father is late. Okay. If yes, so the mother is bringing the son to the UK.
Mm-hmm.
And this, I don't know the status of the mother. It depends. Bafo didn't
the
tell
mother
us
is a dependent.
which immigration state category, as
Okay.
which visa. We don't know which visa because the rules are different. But either way, because the child application is either going to be under paragraph 297 or under paragraph 32 capital A of appendix skilled worker. Now, if it's appendix skilled worker, then paragraph CHI 3.2 of appendix children will come into play. There are three things there: A, B, C. A says that the other parent is dead, and it appears that the other parent is dead, and so the mother has taken full automatic responsibility for the child, and so the surviving parent, that is the mother, has sole responsibility. Oh, it's a student, so student visa. Student visa, again, I don't know when you had a student visa, but for you to have your wife with you, then it means that you guys came before the rules changed. So but who is the main student? Is myself, the main applicant. Okay, my wife is so you are going to bring your stepchild. So yes, she will argue that I have 2.5, or no, not 2.5. I have whatever visa time left. My husband is a student. My child is left. That is his stepchild is left in alone in Ghana. The person looking after the child. So it becomes a case of best interest of the child, whether there is serious and compelling family circumstances that makes the exclusion of the child from the UK undesirable. Even though the mother is the surviving parent, the child is okay in Ghana because somebody is looking after the child. If that is the case, then they will say it is in the best interest of the child to stay there. If that is not the case, then you'll be able to succeed on the point of paragraph CHI 3.2C, which talks about serious and compelling family circumstances that makes the exclusion of the child from the UK undesirable. So the question is, if the child doesn't come to join you, will the child die? If that is the case, then the child will be able to gain entry clearance to join you. Again, it depends on how many years you have for your visa to expire.
Well, Bafor is saying that he's a student. So
Yeah, yeah,
does that
yeah.
change the scenario in any way?
No, we can. I picked that up, and I said a student, a spouse of a student. So he's the student. The spouse is the dependent of a student, and they are applied. So that's why I said that the child is the stepchild of Bafo and the biological child of the wife.
Mm-hmm.
So the wife is applying based on her limited leave as a dependent of a student, and argue that leaving the child abroad alone will not be good for the child in terms of life and death analysis. Otherwise, they will say the child is better placed to remain in Ghana.
All right. Well, as I said, we will be going back to our nugget and, of course, the question. Then we'll come back to pick up your answers. It's a criminal offense to provide immigration advice or services in the UK if you are not regulated or otherwise qualified to do so. Unqualified individuals offering such advice can face imprisonment and fines as specified. Uh, on summary conviction to imprisonment for a term not exceeding 6 months, or to a fine not exceeding the statutory maximum, or to both. Or, again, B, on conviction on indictment to imprisonment for a term not exceeding 2 years, or to a fine, or to both. This based on sections 84(1) and 91A and B of the Immigration and Asylum Act of 1999. And on that, I mentioned whatever the situation we have our friend Peter getting himself into. Peter is a law graduate. He has been advising people in this community on immigration matters. He takes up cases by completing and submitting applications for people, often at a little fee. On one occasion, he advised Sarah about an EUSS application and agreed to submit Sarah's application for her. Sarah's application was rejected because there was no reasonable ground for delaying an EUSS application until July 2025. Sarah has raised a complaint against Peter for the rejection of her application. So we need to advise Peter based on the nugget. We're talking about somebody who may not be authorized to provide immigration advice. Are we going to tell Peter it's not his fault that Sarah did not have any good reason for the delay in submitting her EUSS application? Are we going to say that if Peter can show that he advised Sarah about the likely rejection, then he should be all right? Or we're going to say that Peter has committed a criminal offense and is likely to face imprisonment or a fine, or both, because he provided an immigration service when he was not qualified to do so. Paul has hit the ground running and he says that is number two. If Peter can show that he advised Sarah about the likely rejection, then Peter should be all right. That's Paul. Thank you, Paul. Nanakash also says that is number three. Peter has committed a criminal offense and is likely to face imprisonment or a fine, or both, because he provided an immigration service when not qualified to do so. Rita thinks and agrees with the one answer from Paul to say it's number 3. Thank you. Payal says it's number 1. Peter is not at fault. And Grace Anna thinks it's number 3. Peter has committed a criminal offense. Gifty comes in number 2. Let's see who else has another answer. Grace J thinks it's number 3. Thank you, Gracie. Vivian Dapa talks about number 3. Peter has committed a criminal offense and is likely to face imprisonment or a fine or both. Priscilla Drew also thinks it's number 3. Okay. Let's see who else has anything for us. Mama Sewa says it's number 3. Who else? Mark Brown goes to number 1. It's not Peter's fault that Sarah did not have any good reason for the delay. Isaac or Pong thinks it's number 2. If Peter can show that he advised Sarah about the likely rejection, then he should be all right. Nana Grace also thinks it's number 2 as well. Sandra Williams, number 3. Who else? Let's take one more. Nana Grace thinks is number 2. Uncle Charles. Kathy ends it all with number 3. Is it 1, 2, or 3? Lawyer, we're back to you.
Right. So we are situating the law to the scenario. Peter is a graduate, but there is a qualification to give immigration advice. You must be a solicitor. You must be a barrister. You must be a legal executive, or you must be regulated by the Office for Immigration Services Commissioner. Peter is none of the 4. So Peter is not qualified. That's point 1. The law says that if you are not qualified and you give advice, you commit an offense. On summary conviction, 6 months. That's magistrate court. On indictment, 2 years imprisonment. Summary is where Peter will plead that, oh, I told her, blah, 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 and I still went ahead. You have some mitigation, but it's an offense because you are not qualified. But if it's a willful thing where Peter potentially has been doing it all the time, and it's come to light, then it will be an indictable offense and Peter will go 2 years. So either way, Peter will go in 6 months or 2 years with a fine or without. And so the answer is 3. He's not qualified.
Yes, lawyer has explained and giving us reasons for that. Peter is liable. He's committed a criminal offense because he's not qualified or regulated by the Office of the Immigration Services Commissioner to provide immigration advice or service. Therefore, he's likely to face imprisonment of up to 2 years or a fine of up to the statutory maximum or both. Remember sections 84.1 and 91.1a and b of the Immigration Act of 1999 says so. And remember, section 85, legal aid, sentencing and punishment of Offenders Act 2012 also affirms that. So, Peter, stop it. You are in trouble. Well, we are not, because we have BWF solicitors backing us and giving us support. And this afternoon, this helped us to answer the question whether we knew we could lose our money in our bank account if we were in the UK illegally. What did we talk about? Let's have a summary from lawyer Charles Asma again.
Thank you very much. So, viewers and listeners, today we asked ourselves whether we knew that if we are in the UK without immigration status and we have a bank account that is active and we have money in the account, the law permits the bank to close the account and to keep the money. If we didn't, today we know. Because under Section 40 of the Immigration Act of 2014, as amended in the Act of 2016, the banks have a duty to report people who have no papers, and yet they operate account with them. How would they know? They have your name as an account holder, And every time they will be doing sampling checks. And such sampling checks will flag up names of people who are account holders without papers by comparing them to the database of the Home Office, which they have access to. If it turns out that you have no papers, the law says that the bank should close your account if it is not necessary for them to go through freezing order through the court process. Once they close your account, Home Office will then ask you to tell them if it's a mistake that your account is being closed. Maybe you have become qualified because you have made an application, or you are going to make an application, and that means you have to do it immediately and use it as a defense. If there's nothing like that, then you have no excuse. The money will be kept. A stitch in time saves 9. Speak to a legally qualified immigration lawyer to assist you as to what you can do if you have received such letters, or what you can do if you are worried about this situation because you have an account with money in it and yet you don't have papers. And hearing this, you don't know what to do. Find out for help, because help is in sight.
Find out for help. Help is in sight. Help is with BWF Solicitors. Visit them on the 4th floor of the other house, 214 to 218 Tottenham High Road, Seven Sisters, North London. Call them on 0208 493 7340, 0208 493 7340. Send an email to admin@bwfsolicitors.com, or you can visit the social media platforms as you find on the screen. Leave your questions or DM them and they will get back to you. Or if you're in Ghana, call 05558959959. In emergency situation, 077-127-61884. Ladies and gentlemen, let's say thank you massively to Lawyer Charles Asma for his time this afternoon, and also to BWF Solicitors for giving us the opportunity to come your way with the community and the law, and especially treating this very important topic with you. We thankful to BWF Solicitors, Lawyer Charles Asma, Uncle Ben, Auntie Cynthia, who is our employee of the month of August, and to trainee solicitor and the other solicitors around Eunice, Annie, and Frank. And obviously to the front desk personnel as well, both in Ghana and here in the UK. And to dear Sheila Ankra, want to say thank you for your admin, and also to Padma Dudu for the aesthetics, and to my indefatigable producer, Professor Ade, for putting everything together. My name is Ureku Osu Fripon. Until same time next week, we'll come your way with another edition of The Community and the Law. It's a good evening.